So this leads us to the next topic, minor partner. We discussed about all the other types of partners except for minor partner. Now we'll discuss about the minor partner, or rather minor as a partner. Now the question arises, can minor be inducted in a firm and called as a partner? Can he be admitted as a partner in a firm? If the answer is yes, the next question arises, is he liable for losses? There's one more question which arises, what happens when he becomes a major? Another question arises, is the consent of his parents required to admit him as a partner? So these are some questions which are connected with a minor partner. So let's discuss them one by one and discuss minor as a partner in a partnership firm in detail. So the question is, can a minor enter into a partnership agreement? Now we all know that partnership comes up with a contract, with an agreement. The existence is dependent upon an agreement, upon a contract. We also know this fact that minor is not competent to contract. So now how does he become a partner? Because to form a partnership firm, we need a person who is competent to enter into contract, because partnership is formed by contract. At the same time, minor is not competent to contract. So what do we do now? So prima facie, we can say that minor cannot enter into contracts and thus he cannot become a partner. So this is the prima facie answer. However, we continue saying, however, he can be admitted to a partnership firm for the benefits of the firm. For the benefits of the firm, provided some conditions are satisfied. What are the conditions? First, consent of all the partners is required. Please remember, it is not majority of partners, but it is all partners. Students generally commit a mistake here. Consent of all the partners is required. Second, he cannot be liable for losses. Okay, he cannot be liable for liabilities. He stands with no liabilities whatsoever. And finally, the firm should be an existing firm. It should not be that the minor is the founding partner. He is a partner who is registering the firm, who is founding the firm. He should not be a founding partner. The partnership should already be in existence with two or more partners, and at a later stage they are thinking of inducting minor as a partner. Only then minor can be admitted. So minor cannot form a partnership. Please understand, there is no way that a minor can form a partnership. He can only be admitted to a firm for the benefits of the firm only if the consent of all the partners is acquired, minor stands with no liability whatsoever, and the firm is an existing firm. This is the requirement of law. So I know minor is incompetent to contract. This was settled in a case, you already know, Mohri Bibi versus Dharmodas Ghosh. So in this case, it was settled that minor cannot enter into contracts. He is incompetent to contract, and thus whatever agreements he enters into are void ab initio. Whatever contracts he enters into are void ab initio, that is void from the very beginning. But we said that he can be admitted to the firm. So yes, admission is possible. He cannot form a firm. Admission is possible. The only condition is he cannot be a promisor. That means he cannot contract liabilities. But he can be a beneficiary. That means he can contract benefits, rights, or assets. Getting my point? Minor cannot be a promisor. That means he cannot contract liabilities. He will not be, because promisor is a person who makes a promise and it is his duty to perform the promise. But minor cannot be made liable for any promises. So he cannot be a promisor. He can only be a beneficiary. He can only receive and take, get benefits. He cannot give anything. He cannot be a promisor. So where rights are concerned, assets are concerned, benefits are concerned, he can always take them. But where performance is concerned, losses are concerned, liabilities are concerned, he will never be liable. Okay. So we've already discussed these conditions where minor can be admitted in a firm.